Two people, two different boroughs, two different things they were told the law couldn't do for them. Welcome to State Law Exposed, where we go directly into the statutes, the municipal codes, and the legal protections that exist specifically to protect you, and that the other side spends enormous energy hoping you'll never find. Today, we're in New York. Two cases, two defendants who thought they had already won before a single courtroom door opened. A retired teacher in Upper Manhattan was told his mesothelioma lawsuit was simply too old to file. A Manhattan accountant was hit by a delivery e-bike in a Broadway crosswalk and watched three separate defendants point at each other and walk away. One statute had been sitting in New York law since 1986, waiting for exactly his moment. One municipal mandate had been on the books since 2023, waiting for exactly hers. Neither defendant mentioned either law once, and both of them were counting on the same thing, that the people they wronged would never know the difference. James Whitfield was 61 years old and had spent 28 years of his life inside the same pre-war apartment building in Upper Manhattan. He had watched his neighborhood transform completely around him, laundromats becoming coffee shops, corner bodegas becoming wine bars, while the building itself stayed frozen in time. The pipes were original, the floor tiles were original, and the pipe insulation in the sections of the building that mattered most, the lagging that wrapped the steam pipes running through the common areas and into his apartment walls, was also original. It had been there since before James was born. In November 2025, James's pulmonologist ended a long series of tests with a diagnosis that changed everything. Mesothelioma, the rare cancer of the tissue lining the lungs, caused by one thing and one thing only: asbestos. His physician was specific about the source: deteriorating pipe insulation and floor tile adhesive throughout the building's common areas had been releasing asbestos fibers for years. The building had been renovated multiple times. James had never been warned. He had never seen an air quality test. His landlord had collected rent checks from him for 28 years. James called an attorney the week after his diagnosis. The attorney's response was the kind that ends cases before they begin, delivered with the casual authority of someone who had handled a handful of asbestos cases in the 1990s and assumed the landscape hadn't changed. The attorney told James that asbestos lawsuits were essentially finished, that the major trust had paid out most of their money years ago, that his exposure had happened decades ago, and the statute of limitations was probably a fatal problem. He said it like it was settled fact, like he was doing James a favor by saying it quickly. That attorney was wrong on every single count, and the wrongness would have cost James everything, not because the law had failed him, but because one practitioner had never bothered to learn the statute that made his case not just possible but viable. The name of that statute is CPLR Section 214C. It has been New York law since 1986, and it begins with a deceptively simple principle. In toxic exposure cases, the clock doesn't start when you were exposed. It starts when you find out what the exposure did to you. Mesothelioma is not a condition that waits for legal strategy to catch up. It is aggressive, it is specific, and it demands decisions about treatment protocols, about finances, about what a man leaves behind for the people he loves. James had a daughter living in Westchester. He had a pension built over decades of teaching in the New York City public school system. And he had medical bills beginning to arrive faster than he could process them. A disease he had not contracted inside a building he had every legal right to consider safe. The weight of the first attorney's dismissal was not abstract. It was daily. The idea that 28 years of breathing inside that building, trusting the people who owned it, never asking questions because he had no reason to, might produce nothing, legally speaking, was a specific kind of cruelty. His daughter refused to accept it. She searched for a second opinion the way people search when they know the first answer is wrong, but can't yet prove it. She found an attorney who specialized in asbestos litigation, and the first question that attorney asked was not about the exposure date. It was about the diagnosis date. New York CPLR Section 214C is the governing statute for latent injury claims arising from toxic substance exposure. It establishes what lawyers call the discovery rule, and for asbestos litigation, it is one of the most consequential statutes in New York personal injury law. Under Section 214C, the 3-year statute of limitations does not begin to run from the date of exposure. It begins to run from the date the plaintiff discovered, or reasonably should have discovered, the injury, and its causal connection to the toxic substance. For mesothelioma, a disease with a documented latency period of 20 to 50 years between asbestos exposure and diagnosis, this means the legal clock starts at diagnosis, not in 1987 when James first moved into that apartment, not in 1998 when the renovation that disturbed the most dangerous asbestos occurred. In November 2025, when a licensed pulmonologist confirmed both the disease and its cause. James had not missed his window. His window had not opened yet when the first attorney turned him away. New York City maintains a specialized legal infrastructure for exactly this category of case, and its existence is itself a testament to how seriously the state has taken asbestos litigation. The New York City asbestos litigation part, known as NYCAL, sits within the New York County Supreme Court and manages asbestos claims through a dedicated docket with judges who have deep experience in the specific evidentiary demands of asbestos-related cancer cases. Industrial hygienist testimony, exposure quantification, causation standards for mesothelioma specifically. These are not generic personal injury issues. They are specialized, and NYCAL was built to handle them with precision. Beyond the courtroom, the asbestos bankruptcy trust system remains active in 2026. Dozens of trusts, established through manufacturer and supplier bankruptcies over the past 4 decades, continue to process and pay claims. The amounts are meaningful. The process is specialized, and most general practice attorneys either don't know how to navigate the trust system, are not certified to do so, or, like James's first attorney, assume the trusts are functionally empty when they are not. James's asbestos attorney filed a NYCAL and identified 3 viable defendants: the current building owner, the renovation contractor whose corporate successor remained solvent, and the former property management company that had supervised the 1998 renovation work. An industrial hygienist testified that the 1998 renovation had disturbed friable asbestos, the most dangerous airborne form, without the proper containment barriers required by OSHA Standard 29 CFR 1926.1101 and EPA NESHAP regulations under 40 CFR Part 61, Subpart M. The air monitoring records required under those federal standards were either never created or could not be produced. The building owner's failure to provide EPA-mandated hazard notifications to tenants during renovation created a separate, independent negligence per se claim. The regulation existed, it was violated, and the violation caused harm. The case resolved through a combination of defendant settlements and asbestos bankruptcy trust distributions totaling $4.1 million. The first attorney who told James his case was too old, treated a living statute as if it were dead law, would never know what that dismissal had nearly cost. The discovery rule had been protecting victims like James since 1986. One story down, one to go. And story 2 is built on a different kind of institutional denial. Not the dismissal of an outdated practitioner who never learned a statute, but the confident, lawyerly 3-page letter of a delivery platform that had apparently never read the New York City Administrative Code. Grace Kim was 45 years old, a senior accountant who had lived on the Upper West Side for 11 years. She had walked that Broadway crosswalk hundreds of times. The case resolved through a combination of defendant settlements and asbestos bankruptcy trust distributions totaling $4.1 million. The first attorney who told James his case was too old, who treated a living statute as if it were dead law, would never know what that dismissal had nearly cost. The discovery rule had been protecting victims like James since 1986. One story down, one to go. And story 2 is built on a different kind of institutional denial. Not the denial of an outdated practitioner who never learned a statute, but the confident, lawyerly letter of a delivery that had apparently never read the New York City Administrative Code. Grace Kim was 45 years old, a senior accountant who had lived on the Upper West Side for 11 years. She had walked that Broadway crosswalk hundreds of times. On a Tuesday morning in May 2026, she stepped into it on a walk signal and was struck by a delivery worker on a Class 3 e-bike, racing to be a platform timer. Her wrist was fractured in 2 places. Her knee required arthroscopic surgery. Her medical bills reached $68,000. And within weeks of the accident, 3 separate defendants, the rider, the restaurant, the platform, had each pointed somewhere else and walked away. The platform's letter was the most detailed. It was also the most wrong, because in 2023, New York City had quietly passed a mandate that the platform's legal team had elected not to mention even once. The structure of Grace's situation had been engineered to produce exactly the outcome she was facing. The delivery rider had no personal auto insurance and no meaningful assets, a common profile among gig economy workers who depend on platforms for their livelihood. The restaurant he was delivering from had a general liability policy, and that policy contained a motor vehicle exclusion that the insurer cited in writing within days of the incident. The delivery platform, one of New York City's largest app-based food delivery services, sent a 3-page letter through its legal team. The letter was professionally organized around a single legal theory. The platform does not employ delivery workers, does not direct or control delivery operations, and bears no liability for incidents involving independent contractors. Every word of it was technically accurate as a description of the traditional independent contractor framework. And not a single word of it mentioned Local Law 31 of 2021, or the 2023 New York City legislation that had imposed a mandatory $300,000 per incident insurance requirement on delivery platforms operating within the 5 boroughs. The letter was designed for a legal landscape that no longer existed. New York City Local Law 31 of 2021 was the city's first major legislative step in addressing the liability architecture of the delivery economy, classifying vehicles, establishing safety requirements, and beginning to fill the gaps that delivery platforms had spent years deliberately constructing. The New York City Council went further in 2023. Legislation passed that year imposes a mandatory requirement on app-based food delivery services operating in New York City. They must provide a minimum of $300,000 in liability insurance per incident for their workers while on active delivery. This is not a voluntary program. It is not a best practice recommendation. It is a mandatory insurance requirement enforced through the city's licensing and regulatory framework. A delivery platform operating within New York City without complying with this mandate is, by definition, operating illegally. The independent contractor relationship with the platform's legal team had described so precisely in its 3-page letter may or may not have insulated the platform from employment liability. But the 2023 mandate does not require an employment relationship to trigger coverage. It requires one thing: active delivery. The most powerful piece of evidence in Grace's case was not generated by her attorney. It was generated by the platform. The same GPS system the platform used to track riders in real time, manage delivery queues, and send timer alerts was the system that would determine whether its insurance mandate applied at the moment Grace stepped into that crosswalk. Grace's attorney filed suit in New York Supreme Court, New York County against the delivery platform directly, bypassing the rider and the restaurant whose positions had already been established. Through CPLR Article 31 discovery, counsel subpoenaed the platform's GPS delivery records for the rider and the specific delivery in progress. The data returned was precise. At the exact moment of impact, the rider's account showed an active delivery in progress. Restaurant pickup confirmed. Destination set. Real-time tracking engaged. Platform delivery timer active, showing 3 minutes remaining when the rider struck Grace in the crosswalk. The platform's own operational infrastructure had been watching that rider through every second of his approach to Broadway. It had recorded all of it. The platform's insurer could not dispute its own GPS data. Active delivery confirmed, policy enforced, $300,000 in mandatory coverage available. The 2025 New York State budget further expanded the definition of motor vehicle to include Class 3 e-bikes operating above 20 miles per hour, bringing them within New York's no-fault insurance framework under Insurance Law Article 51, a parallel coverage path the platform's legal team never surfaced. The settlement reached $275,000. The platform's 3-page independent contractor letter, though legally precise for the PRE-2023 landscape, failed to account for one critical shift. New York City's 2023 delivery worker insurance mandate passed specifically because that exact defense had been winning for too long, made $300,000 in per-incident coverage non-negotiable regardless of employment classification. Grace's attorney filed for the law as it stood after that mandate. Grace's attorney won. James Whitfield and Grace Kim faced the same architecture disguised as two different situations. James was told his asbestos case was beyond the statute of limitations without any mention of CPLR Section 214C, which has existed in New York law since 1986 and starts the 3-year clock at medical diagnosis, not at the date of toxic exposure. Grace was told the platform owed her nothing, without a single word about the 2023 mandate requiring exactly the coverage that applied to her case. In both instances, the defense was designed to sound final, to make the injured party believe the matter was closed before it had been properly examined. In both instances, the defense was demonstrably wrong, not ambiguously, but specifically contradicted by a directly applicable New York statute. James's case went through NYCAL. 3 defendants paid. Bankruptcy trust paid, total recovery $4.1 million. Grace recovered $275,000. Both outcomes became possible the moment someone looked at what the law actually said, rather than what the opposing party claimed it said. James and Grace are not exceptions. They are the pattern made visible. Every day in New York, asbestos victims are told their cases are too old without anyone mentioning the discovery rule. Pedestrians struck by delivery workers are told the platform isn't the employer without anyone mentioning the insurance mandate. The first attorney who told James his case was time-barred wasn't lying. He was wrong in the specific, costly way a general practitioner with outdated knowledge of a specialized area is wrong. The platform's legal team wasn't lying either. They were accurately describing a legal landscape that no longer fully applied. CPLR 214C guarantees that latent toxic injury claims begin at diagnosis. The 2023 mandate guarantees $300,000 in platform coverage regardless of contractor classification. Both protections are real, both are enforceable, and both were used in 2026 to produce results the opposing parties had engineered their entire strategies to prevent. The gap between what the other side tells you the law says and what the law actually says is not an accident, it is an architecture. Knowing it exists is the first step to navigating it. Subscribe for more to State Law Exposed.